Thumbs up, thumbs up, thumbs up, thumbs up. Everybody. Get on up in here, get on up in here, get on up in here, get on up in here. All right, what's going on, Conscious Crew? I don't want to keep you guys here long since we have to do quite a bit of reading. But before we do so, please go ahead and run those likes all the way up. YouTube is making a lot of different changes, girl. The system is all out of whack. So, yeah, it don't be too much we can do about that. But we can share, we can subscribe, we can thumbs up the video to let Miss YouTube know that you guys are loving it, honey. And give them whores a reason, honey, to promote the content out to all of the YouTube multiverse. So please run the likes up as you guys are coming in. Thumbs up, up, up. It don't cost you nothing. Speaking of not costing you nothing, you can always donate to the platform at $Consciouztv on Cash App and or PayPal.me/Consciouztv, spelled with a Z on the end, just like it is here on the channel. All donation information is in the description box below. And thank you all in advance for donating, and thank all of those who have donated up to this point, because I did get some PayPal donations as well. I love you guys a long time, and y'all know that a bitch birthday is this coming Saturday, and we will be loud, live, and in color this Saturday for a little while as well, just to have a little birthday chit chat and celebration. Also, make sure that you guys are sharing the stream out to wherever it is you have digital community, whether that be your YouTube community wall, your Snapchat, your MySpace, the dark side of Twitter, Tumblr, or your personal OF. I don't really give a damn where you in fact lay the link. Just let them whores know that we're loud, live, and in color. And with no further ado, let's go ahead and push on through.
I know a place where you can recharge your soul.
Baby, that's Consciouztv.
And in the midst of brokenness, he gon' see your asshole.
Baby, that's Consciouztv.
You gon' heal, you gon' laugh and catch a little shade.
Ooh, girl.
Y'all know he be slaying, y'all better stop playing. Come hear what he's saying.
Ladies and gentlemen.
What is going on, Conscious Crew? Yes, the camera is picking up the hair color so well. The hair is super bright in person as well. I use Adore hair dye. So yeah, if you guys want like really vivid, nice, potent colors for your hair, definitely the Adore brand. She gives it up hardcore, child. This is a ginger. It's like a sunset red gingery color, which I thought was a really nice like spring fall color. Kind of matches the leaves as they transition on up out of here, honey, and leave these bushes buckety necketed, child. What is going on, you guys? Thank you guys so much. I'm probably going to recurl this hair too, because curls are dropping, but they still look really nice. These curls are like, whew, they're about a month old now. And they're still holding up with no retouches. So that Remington curling wand, girl. she's a beast, honey. A whole entire beast. Hold on, you guys. I done did something. Hold on. I done did something, child. Hold on real quick. Mama. You guys want the likes up. All right. So you guys know we just came off of a live stream, girl. We had to get into some Wendy Williams, then we had to get into some Milagro Gramz, and we had to get into some Tory Lanez. Now, you guys said that you guys wanted a full read on Tory Lanez, the response to his appeal, because you guys know Tory Lanez is tired of giving up Boochie Cat Girl for phone time and honey buns. So he been begging the courts court to set him free. So on his 50 million 11th appeal, girl, they told him the same thing that they told him in all the other 50 million 11 appeals, which was, hell no, girl, get comfortable because your ass is going to be serving up the whole 10 years. Now, you guys know Tory Lanez done been sanctioned while he been in prison. He done been stabbed up, sliced up like apple pie during Thanksgiving in prison, girl. He has gone through it, girl. So he has very good reason to be fighting for his life, literally. However, he's where he belongs, and his trial was fair and just. All of the tribunal agrees, and they responded to his appeal with said response, which we have here courtesy of our boo Document Teens. Make sure that you follow Document Teens also on Twitter and YouTube, because he keeps up with all of the Megan Thee Stallion, Milagro scams, trial stuff, girl. Anything having to do with Tory Lanez, girl, he gets into the teens. So make sure that you guys subscribe to Document Teens on YouTube and Twitter. Okay. So let's get into, girl, this nasty piece of response from the 2nd Appellate District Division 3. Because, girl, it's nasty work. It is nasty work, you all. It's a beautiful day, and Tory Lanez lost an appeal on period. Team Meg, girl, Team Meg. All right, appeal from a judgment of the Superior Court of Los Angeles, David V. Hereford, judge affirmed. Girl, we got to read, baby. Y'all better hit that motherfucking Cash App, girl. In December of 2022, a jury convicted Daystar Peterson of assault with a semi-automatic firearm on Megan Thee Stallion. Carrying a concealed unregistered firearm in a vehicle and discharging a firearm with gross negligence, the court sentenced Peterson to 10 years in the state penitentiary. On appeal, hold on, y'all. On appeal, Peterson contends the trial court committed a number of errors. We find no procedural error and accordingly affirm Peterson's conviction. So despite, girl, all his little leprechaun-ass fans, oh, there were so many procedural errors, and there was so much gross negligence, and there was so much sabotage. Yeah, no, there was not, girl. It was a fair trial. So fair that Tory Lanez felt comfortable not even taking the stand, girl. That's how competent trial was, girl, that he felt comfortable not even taking the stand in his own defense. Okay? Facts and procedural background. On July 12th of 2020, Pete went to a gathering at Kylie Jenner's... Do we want to call it a home? That shit is more like a damn haunted house, a cemetery, girl, a place of worship for them goddamn gargoyles and shit. At some point, Pete texted Peterson and told him to come, and she told him to come per Kylie Jenner's request, who was trying to piss off Travis Scott, her baby daddy, because Tory and Scott had beef. So Kylie was wanting to have a few photo ops with Tory to piss off her baby for the Gworllll, the mess of it all. At some point, Pete texted Peterson and told him to come. When Peterson arrived, it was really late. Eventually, Pete wanted to leave. Pete, her friend and personal assistant, Kelsey Harris, and Peterson got in an SUV driven by Peterson's driver, Jaquan Smith. An argument started about the relationship amongst Pete, Harris, and Peterson. Pete walking away, she heard Peterson say, "Dance, bitch." Pete turned her head a little bit and saw Peterson pointing a GUN at her. She froze. Pete heard gunshots. She looked down at her feet and saw all the blood. Pete dropped to the ground and crawled into a driveway. Pete felt pain in both her feet. After that, it got blurry. Pete saw Peterson and Harris walking toward her. Peterson started apologizing. Pete got back into the SUV. They heard police sirens, and Peterson told Pete and Harris, please, y'all, don't say anything. I'm about to sign a big deal. I'll give both of you $1 million each. At 4:27 a.m., Harris sent text to Justin Edison, who handled Pete's security. The text said, help, Tory shot Meg, 911. Police told the SUV they asked everyone to get out. Pete told the police she'd stepped on glass. She didn't tell them she'd been shot. When asked at trial why she told the police she stepped on glass, Pete referred to the then recent murder of George Floyd. Pete testified she didn't know if they're going to shoot first and ask questions later, and she didn't feel safe with the police officers. Officers found a 9mm Luger semi-automatic handgun on the floorboard of the front passenger seat. The gun was in the slide lock position, meaning all the rounds had been fired from the magazine. It was warm to the touch, even though it was cold outside at that hour of the morning. Officers also found a bloody towel in the back seat. The officers took Peterson, Harris, and Smith into custody at the station. Officers checked the hands of all three for gunshot residue. The samples taken from Peterson and Harris were positive for gunshot residue. Okay, the samples from both Peterson and Harris were positive for gunshot residue. For people who were like, why they didn't test? They did test. That's how they knew that Peterson and Kelsey had gunshot residue. Because remember, the direction that Tory Lanez lawyers were going to go in was trying to low-key pin this on Harris, which it would have made sense for her to have GUN residue on her because she also fought Tory Lanez in 2 different instances that night. So that transfer would have been very easy. Let me see. Where was I? A criminalist testified at trial that if Harris had been standing within feet of an individual firing a firearm and came into contact with that individual after he fired a firearm, she would not be surprised if Harris tested positive for gunshot residue. No gunshot residue particles were detected on the sample taken from Smith. Jaquan, it is. An ambulance took Pete to the hospital. Neither in the ambulance nor at the hospital did Pete tell the medical providers that she'd been shot. She later explained, quote, in the Black community, it's not really acceptable to be cooperating with police officers. Pete also said that when a woman accuses a man of something, people have a hard time believing you. She added, this whole situation in the industry is like a big boys club. Like I'm telling all of y'all's friends and now everybody about to hate me. Around 9:05 the morning of the shooting, Peterson called Harris from jail. A recording of the call was played for the jury. Harris told Peterson that Pete was still at the hospital and was waiting outside. Peterson said, quote, I know she probably never, ever going to ever want to talk to me ever again, but bruh, I just want you to know, bruh, Ninja, I was just so effing drunk. I never do some ish like that, bruh. You know, regardless, that's not going to make anything right, and that's not going to make my actions right, bro. But I'm just deeply sorry, bruh. Sorry. So, like, I feel crazy, bruh, but made a mistake. Like, what happened already, bruh. I can't take it back, bruh. I'm just telling y'all I'm sorry, bruh. And, I mean, that was the fucking admission right there. Even the jury, like, as far as they was concerned, the most incriminating evidence in this whole thing was the actual jail recording apology from Tory to Kelsey and both to Megan. At 8:59 p.m. that evening, Peterson texts Pete. The text said, quote, Meg, I know you probably never going to want to talk to me again, but I genuinely want you to know I'm sorry from the bottom of my heart, and I was just too drunk. Nonetheless, shit should have never happened, and I can't change what I did. I just feel horrible because I genuinely just got too drunk. I love you, and I hope you're okay. Peterson sent Pete other text messages just apologizing. Pete had bullet fragments in both of her feet. She had to have surgery and physical therapy. Pete couldn't walk for a while. She can't really feel the left side of her foot. About 4 days after the outing, Pete told police who had shot her, Pete testified she had a change of heart because Peterson had tried to start getting ahead of the story online. Once again, remember when I was telling people that initially Meg was being uncompliant and difficult. And now, once again, they're reiterating that she was. Meg had a change of heart because Tory Lanez started playing on her head top. We literally read the transcripts from the interviews, etc., between her and the DA. They were saying that Meg was being difficult, etc. So I'm just glad that y'all once again know that I'm right, as always, bitch. Like, I read this stuff for y'all. We read together. That's why I don't even be knowing how y'all be forgetting shit. I'm just like, y'all were in the live streams. Y'all were present. Y'all forget. I don't. About 4 days after the shooting, Pete told police who had shot her. Pete testified she had a change of heart because Peterson had tried to start getting ahead of the story online. He put it on a bunch of different narratives about what happened. He was taunting her when he also knew damn well that she had not stepped in no goddamn glass. He knew he had discharged a goddamn gun. He knew she had been popped. He knew all of those things. And before we go any further, let me once again reiterate the evidence, girl, that Megan did not step in glass. She told y'all why she told police that, because she did not want them to George Floyd her and her crew. And all the evidence supports that she was shot, from the surgeon that pulled the foreign metallic objects out of her foot to the eyewitness accounts, including Meg's own account. She saw who ooted her. Kelsey saw who ooted her. And their own witness, Sean Kelly, saw who ooted her. But you know what else accidentally liberated Megan Thee Stallion? Let me see here. Where's the shit at? I just saw it. Hold on, y'all. I'm trying to find. Oh my God. I just literally saw. Hold on. I could have sworn. Hold on. Y'all thumbs up. I'm trying to find something. Because y'all know, girl, we love a good receipt over here. But I can't find the receipt that I'm looking for, and I just literally saw it in the last live stream. So this is really weird. Let me look one more time. I literally just saw this image, girl. I really, what the fuck? And it's probably staring me right in my damn face. Hold on, y'all. Let me look real good, because I'm not giving up. I just saw this motherfucking picture. Oh, here it is. Bloop. And you know what else vindicated Megan Thee Stallion? It was the body cam footage from that night from an officer who had helped to put Meg in the ambulance. So even the body cam footage proves that Megan did not step in no motherfucking glass. That's why you don't see any scarring, bruising, bleeding, etc. from the bottom, from the sole of her feet, girl. Okay, all of her injuries were consistent with being hit by shrapnel from the bullets hitting the ground around Megan Thee Stallion, which is why her injuries were all around her ankles, where you don't walk on. You don't walk on your fucking ankles. For somebody who stepped in glass, how the hell would you end up with scarring and bleeding in the sides and tops of your feet and none on the bottom. So Meg was shot. There was no glass, as she said. All right. Now let's get bike. Because I know some of y'all girls still running with that glass shit, girl. The glass. The motherfucking glass. Ain't been no motherfucking glass. All right, now back to the readathon, child. DNA testing of the Luger revealed a profile of at least 4 people. Peterson could not be excluded or included. His contribution was inconclusive. Okay, so that does not mean he was excluded. It just means that they couldn't prove who DNA it was. They couldn't prove it was Kelsey's. They couldn't prove it was Tory's because there were so many strands of DNA on the GUN. DNA testing of the magazine also revealed a profile of at least 4 people. Peterson was not one of them. No usable fingerprints were found on the GUN or the magazine. Okay, inconclusive. In response to the prosecutor's question at trial, Pete testified that she was having a really difficult time sitting up there and trying to comfortably tell her story. Apparently referring to spectators in a room, Pete said a group of people had been continuously spreading misinformation to make her look like a bad person. One of those people was Milagro Gramz, who was in the courtroom, girl. Okay, and then leaving the courtroom telling lies intentionally because she was an alleged paid surrogate for Tory Lanez. The people charged Peterson with assault with a semi-automatic firearm on Pete, count 1, having a concealed firearm not registered to him in a vehicle, count 2, and discharge of a firearm with gross negligence, count 3. And count 1, the people alleged that Peterson personally used the firearm. And counts 1 and 3, the people alleged that Peterson personally inflicted great bodily injury on Pete. So for all those people who saying he wasn't even charged for ooting her, yes, the fuck he was. And there's a charge right there. The people also alleged that aggravating factors under the California rules of court. The case went to trial in December 2022. Amongst other witnesses, the defense called Sean Kelly. Kelly testified that he lived near Nichols Canyon in July of 2020. Kelly was asleep. He was awakened by lots of shouting and voices. He looked through his window and saw 2 girls arguing. Then they started fighting. They were pulling their hair and hitting each other. It was quite violent. A tall man got out of the driver's side of the car and got involved. That would have been Jaquan. One of the girls went to the car. Kelly then heard what at first he thought were fireworks. He saw a muzzle flash. At about the same time, a smaller gentleman, which would have been Tory Lanez, got out of the back passenger seat. He was shouting a lot. Kelly saw more flashes and what was obviously gunfire. The muzzle flash was near the girls. Kelly then did not hear anyone say dance bitch, although both defense counsel questions and Kelly's answers were unclear. Kelly seemed to say the girl who was the aggressor went to the car and he saw the muzzle flashes coming from her hand. Kelly then said the flashes came from the shorter man. About 2 weeks into the trial, near the end of the people's case, the prosecution moved to add more felony accounts to the information for dissuading 2 witnesses, Pete and Harris, under Penal Code Section 136.1. The court denied the motion. References the statutes or the Penal Code unless otherwise noted. Counsel didn't ask Kelly about a precise date, referring only to an incident that took place in July of 2020. Kelly testified, I believe I saw the girl shoot first. They were both shooting. Kelly never saw a GUN. He called 911. On cross-examination, Kelly admitted that he told investigators that the short guy came out of the car and then he shot the girl. The girl then fell into the road and started bleeding. When asked what was he saying at the time, Kelly replied, a torrent of abuse. It was all just N-words. And you know, F, mother effer. And Kelly also admitted he'd never mentioned a girl involved in the ooting to the 911 operator, nor did he mention a female ooter to the responding officer. Peterson chose not to testify. The jury convicted Peterson on all 3 counts and found the firearm and great bodily injury allegations true. Peterson, represented by new counsel, filed a motion for a new trial. The court conducted a lengthy hearing on the motion. After several days, the court ultimately denied the motion. The court conducted a bench trial on the factors in the aggravation under the California rules of court. The court found true aggravating factors that Peterson used a weapon in the commission of the crime and that the victim was particularly vulnerable. The court also found Peterson's conduct toward the victim after the incident to be an aggravating factor. The court listed social media posts releasing songs with lyrics directed toward the victim, attempts to dissuade or perhaps give money to her and other witnesses. References to rules are to the California rule of court. At the beginning of the trial, Peterson agreed to bifurcate trial on the factors in aggravation and to waive jury on those allegations in violating the protective order. The court stated, I think this is a very significant aggravating factor in this case. The court added that there was 2 times that he violated the protective order where the court had to step in and raise his bail. The court found not true the prosecution's allegations that the crime involved a high degree of cruelty, viciousness, or callousness within the meaning of Rule 421A1. The trial court increased Peterson's bail several times between his arraignment in November 2020 and trial December 2022. In August of 2021, the court granted the prosecution the motion to increase bail. As a condition of bail, the court ordered Peterson not to attend or appear at events where Megan P. is scheduled to appear. In April 2022, the parties appeared before the court to discuss another motion. The prosecution had failed to increase bail. The prosecution referred to a music video where he's depicting violent imagery coupled with lookalikes in the video of Pete and her boyfriend. This apparently was a reference to a music video Pete mentioned in her testimony at trial showing Peterson chopping up horse legs. You guys, thumbs up, thumbs up, thumbs up. Based on the exhibits the prosecution presented, the court found Peterson in violation of both the protective order and the discovery order. As a condition of bail, the court told Peterson, sir, you are not to mention Pete in the case or anything that this case in any social media or any public statements, either directly or indirectly. In October 2022, the parties appeared before the court yet again on the prosecution's motions to set a bail, no bail. The court denied the motion but ordered electronic monitoring house arrest for Peterson pending trial. The record on appeal includes reporters and clerks' transcripts of the bail proceedings, but not the motion's opposition briefs or exhibits filed in connection with them. The court also found 3 mitigating factors: that Peterson had no prior record or an insignificant record of criminal conduct, that he had actively participated in charitable or philanthropic causes, and that he did not pose a significant risk of reoffending in a violent manner. Well, they apparently didn't do their goddamn homework because he had just settled out of court with Prince for busting him all up in his motherfucking mouth at a nightclub. Before, he had also bust August Alsina all up in the motherfucking mouth and left his ass bloody. August Alsina just didn't pursue charges, and this be the problem with people not pursuing them charges. Before pronouncing sentence, the court heard from several witnesses caught by Peterson. The court also listed the authors of 72 letters it had received from Peterson's supporters. A prosecutor read aloud a letter written by Pete as a victim impact statement. The prosecution asked the court to sentence Peterson to 13 years in the state prison. The court sentenced Peterson to 10 years. The court found the aggravating and mitigating circumstances were a wash. The court selected the midterm of 6 years on count 1, assault with a semi-automatic firearm. The court also chose the midterm of 4 years for the firearm enhancement on count 2, carrying a concealed unregistered firearm in a vehicle. The court sentenced Peterson to the midterm of 2 years to be served concurrently with count 1. The court stayed under this section 654, the sentence on count 3, discharge of a firearm with gross negligence as to both counts 1 and 3. The courts dismissed the great bodily injury enhancement under section 1385, subdivision C2, presumably in accordance with Senate Bill number . The trial did not abuse its discretion in permitting the prosecutor to ask Pete questions directed to her inconsistent reports to police and her attitude about the case and about testifying. Peterson contends the trial court abused its discretion in allowing testimony and evidence concerning Pete's emotions about the incident and its aftermath. On direct examination, the prosecutor asked Pete questions about her initial statements to law enforcement and medical personnel that she cut her feet on glass. Pete responded that when a woman says a man did something to her, people have a hard time believing you. Pete said she never wanted to come forward. I didn't want to say nothing in the first place. Defense counsel objected to 9 questions along these lines. The court overruled 5 of the objections and sustained 4. On cross-examination, defense counsel repeatedly asked Pete if she had lied. Now let's get into this transcript, y'all, because this is interesting. Question: you also on CBS were asked a couple of times if you had some type of actual relationship with my client, correct? Answer was yes. Question: and you lied, correct? Yes. You lied on national TV, correct? Yes. You also lied on the prosecutor. You also lied to prosecutors, correct? Yes. You also lied to Detective Stockner about the issue about their relationship, correct? Yes. I remember when I brought this up to people when we was talking about the incident after we had already read all the transcripts. People was like, no, she never lied. She never lied to the... Yes, she did. We read the fucking transcripts, and we read Detective Stockner specifically talking about Meg being difficult and lying about sleeping with Tory Lanez, etc., blah, blah, blah. On redirect, the prosecutor asked Pete questions that were follow-ups to areas defense counsel had raised. Pete testified that people had been making up things and putting out different stories that weren't true, saying that I had never been shot at all. So Pete continued, I had to come out and say, yes, I was shot. I didn't just step on glass. I should have told the truth initially. I know that now. And I thought I was trying to protect people. I thought I was doing the right thing. I thought I was protecting myself. But in the long run, I wasn't. Well, you were protecting y'all. I don't even blame Megan for lying to the authorities initially. Relevant evidence is evidence having any tendency and reason to prove or disprove any disputed fact that is of consequence to the determination of the action, such as in case laws there. Even if evidence is relevant, Evidence Code Section 352 gives the trial court discretion to exclude it if its probative value is substantially outweighed by the probability that its admission will create a substantial danger of undue prejudice, such as in case law there. The prejudice that exclusion of evidence under Section 352 is designed to avoid is not the prejudice or damage to a defense that naturally flows from relevant, highly probative evidence, such as in case laws there. The prejudice that Section 352 refers to, it's evidence that uniquely tends to evoke emotional bias against the defendant as an individual, and that has very little effect on the issues. In general, the trial court is vested with wide discretion in determining relevance and in weighing the prejudice, the prejudicial effect of preferred evidence against its probative value. Its rulings will not be overturned on appeal absent of that discretion, such as in case law there. A trial court abuses its discretion when its decision exceeds the bounds of reason or is arbitrary, capricious, patently absurd, or even whimsical. God damn. Such as in case laws there. Put another way, a ruling that constitutes an abuse of discretion has been described as one that is so irrational or arbitrary that no reasonable person could agree with it, such as in case law there. Peterson contends that the prosecutor's question to Pete regarding how she felt about coming into court today was improper, and the trial court permitting it was inexplicable. Peterson is mistaken. The court instructed the jury, as courts do in every criminal trial, on a non-exclusive list of 11 factors jurors may consider in judging the credibility or believability of a witness. One of those factors is what was the witness's attitude about the case or about testifying. Other factors include, did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? And did the witness admit to being untruthful? Pete's credibility was a key issue in the case. Indeed, in cross-examination, Peterson's counsel repeatedly asked Pete to admit that she lied. Peterson also asserts this testimony was irrelevant and prejudicial because it is elicited sympathy for the victim. However, at the outset of the trial, the court instructed the jury, quote, your verdict must be based only on the evidence presented during trial in the court and the law as I provide it to you. The court also told the jury, do not let bias, sympathy, prejudice, or public opinion influence your decision. And before closing arguments, the court again instructed the jurors, you must not let bias, sympathy, prejudice, or public opinion influence your assessment of the evidence or your decision. We presume the jury understood and followed the court's instructions in reaching its verdict. Peterson contends the trial reversibly erred in admitting evidence of Peterson's creative expression, specifically a photograph that showed tattoos on his torso and arms. At trial, Officer Sandra Gworllll testified that she and her partner stopped a vehicle that matched the description of a vehicle in a radio call they received. 4 people later identified as Peterson, Pete, Harris, and Smith were in the vehicle. An ambulance took Pete away, and Gworllll and her partner arrested the other 3 and took them to Hollywood Station for further questioning, as the officers had found in the vehicle a hand GUN that was warm to touch and in the slide lock position. They got to the station. They tested Peterson, Harris, and Smith for gunshot residue. So all of them were tested for gunshot residue. The prosecutor marked as exhibits 3 photographs taken at the station that depicted Peterson, Harris, and Smith respectively, and a photo marked as exhibit 18. Peterson appears to be wearing black shorts or swim shorts. He is shirtless and tattoos on his chest and arms are visible. In a photo marked as exhibit 19, Harris appears to be wearing a black 2-piece swimsuit. Tattoos are visible on her arms and left thigh. In a photo marked exhibit 20, Smith appears to be wearing black pants and a long sleeve black top. At sidebar, Peterson's counsel objected to the photograph, arguing that it was irrelevant and would only sway the jury because it looks like he got tattoos. The court replied the photos were to show who the people are that she, referring to the officer Gworllll, took the swabs from. The court continued, I don't see anything wrong. He has no shirt on. He has tattoos. Other than that, what's wrong with the picture? At the conclusion of the evidence, the court discussed the exhibits with counsel. When the court also asked defense counsel if he had any objection to the admission into evidence of exhibits 18, 19, or 20, he replied, no, your fucking honor. So Tory Gworllll was making baseless fucking claims that made no fucking sense. She's just throwing shit up against the wall in his appeals, girl. With anything he had, including arguing that, girl, these pictures of them taken down to the police station prejudiced the jury because they would conflate tattoos with bad behavior and people who do very bad things. My God, today. This desperate child. Desperate child. In support of his claim of reversible error, Peterson cites evidence code section 352.2 Assembly Bill. The statute requires trial courts to consider certain factors when a party seeks to admit as evidence a form of creative expression in any criminal proceeding. The statute defines creative expression as the expression or application of creativity or imagination in the production or arrangement of forms, sounds, words, movements, or symbols, including but not limited to music, dance, performance art, visual art, poetry, literature, film, and other subject art and other such objects or media. My God, today. Peterson cites People versus Venable and case law there. In Venable, the Court of Appeal held evidence code section 352.2 applies retroactively to cases that are not yet final. In his opening brief, Peterson failed to note that our Supreme Court had granted review of Venable some 9 months earlier. Peterson also failed to cite either of the two cases that reached the opposite conclusion, such as People versus Slayton. In his reply brief, Peterson acknowledged the grant of review and mentioned Slayton. Peterson stated he relied on his previous argument pending a final outcome in the high court. On August 28th of 2025, our Supreme Court held in Gworllll Supra 18th Cal 5th 629, the Evidence Code Section 352.2 does not apply retroactively. Gworllll involved handwritten rap lyrics and instant messages attributed to the defendant. Chief Justice, I'm not even going to fuck up his last name, Mr. G, explained that the High Court, having examined the language of Evidence Code Section 352 and its uncodified legislative findings, saw nothing that clearly and unavoidably reveals an intent to depart from the general rule of prospective-only application. Accordingly, Evidence Code Section 352 does not assist Peterson. In any event, the record does not support Peterson's contention that Exhibit 18 injected racial bias into the proceedings. The prosecution did not offer the photograph as evidence of any alleged gang affiliation. There was no gang affiliation in this case, and no one ever suggested that Peterson had any gang ties. The prosecution offered Exhibit 18 and Exhibits 19 and 20, and the court admitted them into evidence solely to show the identity of the individuals officer swabbed for GUN shot residue at the police station. The record does not reflect whether Peterson was wearing a shirt when police stopped his vehicle. Pete testified they just emerged from the swimming pool. She was wearing a bikini, and Harris was in a swimsuit too. Pete stylist Eric Gumberson, called by the defense, also testified both Pete and Harris were wearing swimsuits when they got into the SUV. Cumberson, also known as EJ, also testified Peterson was wearing drawers when they left Jenner's home. In his closing argument, Peterson's counsel referred to what Peterson was wearing as his trunks. There was no testimony at trial that Peterson had been wearing a shirt. The officers asked him to remove it in order to swab his hands for GUN shot residue or to take his photograph. Peterson asserts the prosecution explicitly and improperly introduced racial bias into the proceedings by asking a witness about what appears to be a tattoo of a firearm in the middle of Peterson's chest. Defense witness EJ testified that he was Pete's. Oh, this wasn't EJ, actually. This was somebody else. Defense Cumberson testified that he was Pete's stylist and friend. Oh, no, yeah, this is EJ. He sometimes was Pete's driver as well. From the questioning, it appears the defense called Cumberson to ask him if Pete or Harris had a GUN in their luggage. On direct examination, defense counsel also asked Cumberson if he'd ever seen Tory with a GUN. EJ replied no. Counsel asked if Peterson ran with GUNs. EJ said no. On cross-examination, the prosecutor asked EJ a series of questions about whether he'd ever seen Harris with a GUN and whether he'd seen Pete with a GUN at any time that day or night. He did not ask EJ if he had ever seen Peterson with a GUN. On redirect, defense counsel then asked EJ if he'd ever seen Peterson with a GUN, if he'd ever seen Peterson have a bag that had some weapons with him, and whether he'd ever seen Peterson discuss anything about firearms. EJ answered no to those questions. On recross examination, the prosecutor and EJ had the following exchange. Question: now, counsel asked you if you'd ever seen Tory talk about GUNs or if you'd ever seen him with GUNs. Do you recall that? Yes. Do you see the big GUN that Tory has tattooed on the center of his chest? No, I haven't seen Tory's body. Defense counsel did not object to that question. In short, the record does not support Peterson's contention that prosecutors utilized Peterson's tattoo, which is intertwined with his rapper's persona, to lead jurors to conclude that he was a violent criminal with a predisposition to commit crimes. It was defense counsel who asked both on direct and redirect if EJ had ever seen Peterson with a gun. Neither of the prosecutors ever mentioned Peterson's tattoos, much less the tattoo of a firearm. in their closing arguments. Peterson also complains that Pete's testimony about a music video Peterson had released poisoned the proceedings by directing the jury to infer that if Peterson was chopping up horse legs in a music video, he was violent enough to oot her. Peterson seems to be referring to Pete's answer to the prosecutor's question about whether she regretted having come forward. Quote, if I would have known that coming out and speaking my truth would come with people agreeing with me being shot, if I would have known, I would have started to lose my confidence, lose my friends, lose myself. I didn't ask for this. I didn't want to come out about it in the first place. I started to feel like, damn, maybe I should be dead. I got to watch Tory drop music videos, chopping up horse legs and people laughing at it like that's okay. Defense counsel did not move to strike Pete's reference to the music video. No such music video was offered into evidence or shown to the jury. In any event, Pete's brief reference to the video, which she took as directed at her, even as a threat, was permissible for the same reasons we've already discussed. It's relevant to Pete's attitude about the case or about testifying. Peterson asserts the jury did not hear Peterson's account regarding the night in question because the court ruled that if he testified, prosecutors could introduce his music video and rap lyrics during cross-examination. Peterson mischaracterizes the record. Midway through the defense case, the prosecutor told the court that he was asking to inquire about prior acts of violence if Peterson testified to rebut the character evidence put on by the defense. The court replied, well, I think the state of the evidence as it is now, I would not allow that. Of course, I don't know what he would say if he testifies. It may become relevant depending on what he were to say, but at this point, I would exclude that. The prosecutor listed a number of items with which he proposed to impeach Peterson, including social media posts, rap lyrics, Instagram posts, a 2019 Miami incident, a 2022 incident with August Alsina, an incident with Love and Hip Hop star Prince at a Florida nightclub, and more. The court stated some of this would be admissible, those portions that pertain to this case, some wouldn't. The court continued, the best I can tell you at this point is that if your client testifies, I'll have to take it on a case-by-case basis, but essentially anything pertaining to this case obviously is fair game. If it pertains to some other incident, maybe it is, maybe it isn't. It depends. After the defense had called 7 witnesses, the following exchange took place. Quote, the court. So, Mr. Madison, you advised me that your client has elected not to testify. That's correct, Your Honor. So, Mr. Peterson, you know you have the absolute right not to testify if that's your decision. If you testify, you will take the stand and be questioned just like all the other witnesses were by both sides. If you choose not to testify, I will instruct the jury not to consider it or not to hold it against you. But you understand what I told you so far. Mr. Peterson says, yes, Your Honor. The court says, have you had a chance to discuss that decision with your attorney? I have, Your Honor. And based on your decision, is it your choice at this point not to testify? I will not testify. Neither Peterson nor his counsel ever told the court that Peterson wished to testify, but was deterred by the prospect of impeachment by the prosecution. In case law here, the Supreme Court considered a case like this one in which a defendant did not testify and then argued on appeal. The court had abused its discretion in denying its motion in Lemon to preclude the prosecution from asking about a prior conviction. The court stated, quote, a reviewing court is handicapped in any effort to determine if a trial court performed the necessary balancing because to conduct that review, the court must know that the precise nature of the defendant's testimony, which is unknowable when, as here, the defendant does not testify. In Lucy, as here, there was no commitment by the defendant that he would testify if his request to exclude possible impeachment were granted, nor did he make a proffer to the court as to what his testimony would be. So basically, Tory Lanez didn't testify because the stakes would have been too high, considering all the goddamn evidence against him, all his prior violence against other public figures and celebrities, all these antagonistic ass imageries in his videos, his lyrics, etc., girl. And he, and because the judge couldn't promise that certain things outside of the case would not come back to haunt him, they rightfully so Tory and his legal team, that is, you know, the right to fucking testify, because it obviously would have been a loss by a landslide, because yeah, that perpetual abuse against other public figures outside of Megan, baby, that was going to ultra seal the damn deal 2.0. But now he's trying to misquote the courts as if they somehow talked him out or whatever, girl. So the courts are clearing their name and saying, girl, you miscategorizing this, miscategorizing that, which is what Tory Lanez does. He's a narcissist. He twists up the truth. And this is how he got his dumbass fans to feel how they feel, and ultimately used the same tactic to get scams in the position that she's in, fighting for her goddamn life like a motherfucking dummy. Moreover, a reviewing court cannot assume that the adverse ruling motivated a defendant's decision not to testify, and even if these difficulties could be surmounted, the reviewing court will still face the question of harmless error. The Supreme Court concluded the careful weighing of probative value and prejudicial effect required of a trial court can only be evaluated adequately on appeal in the specific factual context of a trial as it has unfolded, such as in case laws all up and through there. It is well established that the denial of a motion to exclude impeachment evidence is not reviewable on appeal if the defendant subsequently declines to indeed testify. The Luce court's reasoning is directly on point here. Peterson argues Luce does not apply because, one, that case involved possible impeachment with a prior criminal conviction, and two, evidence code section 35.2.2 would have required the court to exclude all of the following impeachment evidence. We are not persuaded. Nothing is Luce suggests its holding is limited to impeachment with a prior conviction as opposed to other types of conducts or acts. As we have said, evidence code section 352.2 does not guide us in this appeal. Peterson asserts that in inculpatory statements which were inculpatory as to the Uter's identity were improperly introduced in spite of their factual falsity. Peterson apparently is referring to Pete's testimony that shortly after the outing, when she and the others heard police sirens and Peterson offered her and Harris $1 million. Peterson said, I can't go to jail. I already got caught with the GUN before. Don't tell on me. A few questions later, the prosecutor asked Pete, what was he saying exactly? Pete replied, I'll give you $1 million if you don't say anything. I can't go to jail no more. I'm already on probation. In the defense case, Peterson's counsel recalled the lead detective, Ryan Stalkner. Counsel questioned Stalkner about his interview of Pete after the outing. Counsel asked if Pete had told him that Peterson stated, please don't say anything because I'm on probation. Stalkner began to answer it was something to that. When the prosecutor objected, the court overruled the objection. This exchange followed. Question, sir, did you do any investigation afterwards to find if my client was on probation at the time this case was happening in July of 2020? Yes. Was my client on probation? Sir, no, not to my best recollection, sir. After defense counsel asked Stalkner about probation, the prosecutor began to ask a question about it. Defense counsel objected. At sidebar, the prosecutor told the court Mr. Lanez was actually on a Florida-Miami probationary term that started in 2017. She added that even if that were not the case, defense counsel was accusing the victim of lying about what Peterson had said. Defense counsel stated Peterson got arrested in the Miami case but was never charged. Outside the jurors' presence, the court and counsel discussed the matter at some length. The prosecutor told the court the defendant was ordered diversion for a GUN possession in 2017. He released an Instagram live video where he talks about going to his probation officer. After more discussion, the court stated, I will allow you to inquire that there was an incident in 2017. He was forced on court diversion. Don't mention what the arrest was for, and we'll leave it at that. Later, defense counsel and prosecutors stipulated to advise the jury that Peterson was ordered a grant of diversion for a criminal case in 2017, and that the diversion was terminated in April of 2017. The court told the jury the stipulation meant that is a fact that's not in dispute in this case, and they were to accept that as conclusion conclusively proven. Both counsel agreed to a special jury instruction about diversion. In accordance with the agreement, the court instructed the jury about the nature of diversion. The instruction stated diversion and probations are not the same. You are not to speculate about the circumstances of Mr. Peterson's grant of diversion in 2017. It was terminated in 2017, and you are not to conclude from this evidence that Mr. Peterson had a bad character or that he's disposed to commit crime. Thus, after the prosecution asked Pete about Peterson's statements, defense counsel raised the issue of probation with the detective in any effort to show Pete lied to the police. Pete's testimony that Peterson said he had been caught with the GUN before was not false. In any event, Peterson's counsel reached an agreement with the prosecution to present a stipulation with the true facts to the jury and for the court to instruct the jury on what diversion means. The record does not support Peterson's claim of error in this point. Losing by a goddamn landslide, trying to play semantics with the courts. Peterson contends that the trial court reversibly erred in permitting the prosecution to play for the jury in recorded interview with Kelsey Harris. Peterson relies on the confrontation clause, and in case law here, the issue is one of admissibility under the evidence code. It does not involve the confrontation clause. The prosecution subpoenaed Harris to testify at trial. The court had appointed counsel for Harris, and the prosecution had granted her use immunity. Once on the stand, to say Harris was a reluctant witness is an understatement. Harris repeatedly claimed not to remember what had happened that early morning and in the days following the outing. Question after question, Harris replied that she didn't remember, couldn't remember, or didn't know. She repeatedly said it was a blur. Several times, Harris said she wanted to plead the fifth. The court told her she had to answer the questions. Harris repeatedly said, "I don't want to be here." In an attempt to refresh Harris's recollection, the prosecutor played excerpts of a recording of a September 14, 2022 interview. The prosecutor had interviewed Harris in the presence of her husband and an investigator from the district attorney's office. Two attorneys representing Harris were present on the phone. Again and again at trial, Harris told the prosecutor she'd have to refresh her recollection with the recording. Confronted with her prior inconsistent statements, Harris testified that there was some things that she wasn't just being truthful about in her interview. Harris also testified that she didn't remember telling prosecutors things that she can be heard saying in the recording. When asked if she had said in the interview that she'd seen Peterson shoot through the window and to the top of the door, Harris replied again, "This is the night of alcohol. I don't know. In light of Harris's claimed failure to recall what she told the authorities and her testimony that she had been untruthful in some of her statements, the prosecution proposed to play the recorded interview for the jury. Citing evidence code section 770 and 1235, the court said it would allow that. Section 770 generally governs the admissibility of extrinsic evidence of a witness's prior inconsistent statement for impeachment. The statute requires only that the witness be given an opportunity at some point in the trial to explain or deny the inconsistent statements. Section 1235 provides evidence of a statement made by a witness is not made inadmissible by the hearsay rule if the statement is inconsistent with his testimony at the hearing and is offered in compliance with section 770, where the out-of-court statement is inconsistent with the witness's trial testimony, the jury may consider the prior statement for its truth as well as for the light it sheds on the witness's lack of credibility. So the prior statement has a dual purpose. It may be considered for impeachment as well as substantive evidence. When a trial court concludes on substantive evidence that a witness's professed lapses of memory are false, evasive devices to avoid truthful answers, it may admit as inconsistent the witness's prior statements describing events the witnesses now claim to have forgotten, such as in case laws there. Peterson contends the trial court reversibly erred in admitting an allegedly inculpatory Instagram post, which was disclosed to the defense in an untimely fashion, amounted to inadmissible hearsay and was highly prejudicial, therefore resulting in a manifest injustice. We do not, in fact, agree. After the juries were selected on Thursday, the court excused them so it could discuss various issues with counsel before opening statements set to begin on Monday. During that discussion, the prosecutors told the trial court and defense counsel that they just been made aware of a September 2020 Instagram post by the defendant in which he said a comment posted by someone else that Harris shot Pete was not true. The prosecutor gave that information on a CD to defense counsel, who said he'd look at it, but he thought there might be a foundation issue. The following Tuesday, the prosecution filed a motion to admit the defense statement on Instagram. The prosecution attached to its motion a photograph of a post by Lil Ju Made the Beat that said, quote, "This goofy ass ninja say he ain't shoot her, and they literally have matched the bullets from his GUN to the ones in her foot." Below is the statement, liked by Frosted Cupcake and 281,393 others. Next, by the Shade Room, hashtag Megan Thee Stallion's producer alleges that authorities have matched the bullets from Tory Lanez GUN to the ones found in her foot. Under that view, all 13,000 comments. Next, Spliff K says, quote, "People saying Kelsey shot her carrying. People said Kelsey shot her." Finally, a post by Tory Lanez at Spliff K says that's not true. The date on the post is September 25th of 2020, and we also show that screenshot here directly from Tory Lanez's verified Instagram page. 2 days later, the court discussed the Instagram post with counsel, citing People versus Valdez. Quote, if people establish the requisite, I don't fuck that word up too, foundation, namely that the account is linked to a certain individual, that goes more to the weight of the evidence than to the admissibility. Now, if I'm not mistaken, I think Tory argued that while it was his actual Instagram profile that made that account, that he doesn't in fact control the account. So conveniently now, he doesn't run his own social medias, and it was someone on his team who made that statement, which I find hard to believe. I find it inconceivable that somebody on Tory Lanez's team who's running his account is responsible for dilly-dabbling in comment sections during an open investigation, and where there's going to be a trial that could put Tory Lanez away for God knows how many years. That whomever was responsible, whoever was the social media handler, whoever was the social media manager, would have been stupid enough to make any statement on Tory Lanez's behalf from his account about a subject like this. No, girl, you called yourself clearing Kelsey's name, and now you were shook because that was going to contradict and make it difficult for your legal team to pin this whole thing on Kelsey as the Uter, which is what y'all were prepared to do. 2 days later, the court discussed the Instagram post with counsel. Detective Warren Ebenhart then testified. Ebenhart stated that he had clicked on the Tory Lanez hyperlink and that the prosecution X'd out 3 letters in the post. Oh, hold on. Those are the whatchamacallit notes. That he had clicked on the Tory Lanez hyperlink, and that directed him to an Instagram page where the username was Tory Lanez. Ebenhart explained that the blue check on the page was essentially a verification badge. Ebenhart testified the Tory Lanez account has 11.8 million followers. He noted photographs on the account appeared to depict Peterson. On cross-examination, when asked, quote, do public figures have people who run their Instagrams? Ebenhart replied, that's fair to say yes. Ebenhart testified that he never said Peterson made the post, adding that he could only testify to the username of the account that the post came from. Ebenhart stated that he did not know who was controlling Peterson's account. Defense counsel marked in Exhibit E and showed to Ebenhart in Instagram posts, apparently from user Mid Jordan, replying to Messiah Carey, The post states, quote, "This is not real. Y'all want to believe anything. I'm the only person who with access to Tory's account at this moment." Defense counsel noted the post had been liked by Tory Lanez. Ebenhart testified that he had never seen the post. When the time came to discuss with counsel the admission of the exhibits, defense counsel said he objected to Exhibit 40A, the Instagram post, and Exhibit 40B, photographs on the account on Foundation. The court admitted the exhibits over counsel's objection. Defense counsel moved the admission of Exhibit E. The court stated it wasn't sure any foundation was laid. The prosecution objected on that ground, and the court sustained the objection. The court noted the exhibit's exclusion did not preclude from arguing that any post would have come from any other person than Peterson, and counsel did so. On appeal, Peterson complains of late discovery. Counsel never made this objection during trial. He did not ask for a continuance exclusion of the exhibits as a discovery sanction or a jury instruction. It was not until Peterson filed his motion for a new trial that he first raised the question. Peterson has forfeited the timelessness issue on appeal. Peterson also asserts the Instagram posts are inadmissible hearsay. A trial court's ruling on the admissibility of evidence, including on the hearsay nature of the evidence in question, is reviewed for abuse of its discretion, such as in case law there. We need not reach the question of any abuse of discretion here, and we see none in any event because Peterson did not object to the exhibit submission on this ground at trial. He raised it for the first time in his new trial. Peterson's failure to object to the post or hearsay at trial also forfeits that argument on appeal, such as in case law there. Finally, any error in admitting the Instagram post was harmless, as the trial court noted the Instagram post was an extremely minor issue in the case. The case turned on Pete's testimony, Peterson's admissions to Harris when he called her from jail, and other similar evidence. Detective Ebenhart testified that he was not saying that Peterson had posted the statement. That's not true, and he admitted that he had no knowledge of who controlled Peterson's Instagram account. So Tory ass is making new arguments that baffle the courts, because they're like, girl, these are things that you weren't even contesting or objecting to or overruling or rebutting, etc. during trial. Now, all of a sudden, girl, you are presenting this, that, and the third, which is weird because, I mean, not only are what you are arguing baseless and groundless, because we cleared everything that we allowed and didn't allow, but don't you think that it would have been better for you to have been this combative during trial when it actually counts? So they're basically just calling him full of fucking shit, and they're clocking that, I mean, he doesn't have anything to work with, girl. You know, it's all smoke and mirrors. And no wonder he fired his whole goddamn team, because, I mean, my God. I mean, they didn't know that the courts had did their due diligence in the trial, because the courts are laying his ass out, girl, like a flat iron shirt. Peterson contends the trial court reversibly erred in its instructions to the jurors on count 1 and 2. Count 1 alleged assault with a semi-automatic firearm in violation of Section 245 submission, and count 2 alleged having a concealed unregistered firearm in a vehicle in violation of Section 254.00 subdivision A and 1. And count 1, the people also allege that Peterson personally used a firearm in the commission of the offense within the meaning of Section 12022.5 and subdivisions A and D. And the conference on jury instructions, the trial told counsel that it would give the Kyle Crim, Civil Code 250, Union of Act and Intent, general intent. The court continues. So all three counts here are general intent crimes. Defense counsel did not disagree or object. Peterson's argument on appeal is somewhat difficult to understand. He asserts assault with a semi-automatic firearm is a general intent crime, yet the enhancement attached to this count through penal code section there requires specific intent Peterson does not cite any case in support of this contention. No case has held that assault with a semi-automatic firearm or a personal use of a firearm enhancement requires specific intent. To prove assault with a firearm, the prosecution must prove: 1, the defendant did not act with a firearm that by its nature would indirectly and probably result in the application of force to a person, and 2, the defendant did that act willfully. 3, when the defendant acted, he was aware of facts that would lead to a reasonable person to realize that his act by its nature would directly and probably result in the application of force to someone, and 4, when the defendant acted, he had the present ability to apply force with a firearm to a person. Thus, this instruction requires a defendant to have acted willfully and with awareness of facts that a reasonable person would recognize would result in the application of force to a person. The jury instruction defines willfully as someone who commits an act willfully when he does it willingly or on purpose, as opposed, for example, to accidentally. The word willfully implies simply a purpose or a willingness to commit the act. It does not require any intent to violate law, to injure another person, or to acquire any advantage. The word willfully, when applied to the intended, with the other case law. Peterson contention regarding count 2 requires more discussion. Peterson asserts, likewise, count 2 is a specific intent crime and required instruction with a Gworllll number 252. That instruction is entitled Union of Act and Intent, General and Specific Intent Together, to prove the offense of carrying a concealed weapon within a vehicle. The prosecution must prove: 1, that the defendant carried within a vehicle a firearm capable of being concealed on the person; 2, the defendant knew the firearm was in the vehicle; and 3, the firearm was substantially concealed within the vehicle; and 4, the vehicle was under the defendant's control or direction. Knowledge is not the same thing as specific intent. The word knowing, as used in a criminal statute, imports only an awareness of the facts which bring the proscribed act within the terms of the statute. However, knowledge is a required mental state for a violation of the statute. For the first time in his reply brief, Peterson cites the bench note to Gworllll number 250. The note states, quote, "This instruction must not be used if the crime requires a specific mental state, such as knowledge, even if the crime is classified as a general intent offense. If the case involves both offenses requiring a specific intent or mental state and offenses that do not, the court may give Gworllll number 252. We review the adequacy of an instruction independently, such as in case law there and there and there and there. From the bench note to Gworllll number 250, it appears the trial court should have given the jury Gworllll number 252, listing assault with a semi-automatic firearm and the firearm enhancement as requiring only general criminal intent, but listing carrying a concealed weapon within a vehicle as requiring the specific mental state of knowledge. However, on this record, the court's failure to do so was harmless. In reviewing a claim of instructional error, the court must consider whether there is reasonable likelihood that the trial court's instruction caused the jury to misapply the law in violation of the Constitution, such as in case law there. We review the challenge instruction in the context of the instructions as a whole and the trial court record to determine whether there is a reasonable likelihood the jury applied the instruction in an impermissible manner. Instructional error requires reversal of the judgment only if it resulted in a miscarriage of justice, meaning it is reasonably probable the defendant would have fared better in the absence of the error, such as in case law there. The trial court did instruct the jury that the prosecution was required to prove not only that Peterson committed the prohibited act, but that he did so with wrongful intent and that he knew the firearm was in the vehicle. In closing, the prosecutor argued Peterson knew The GUN, was there? Of course he did. He grabbed it. He shot Megan with it. Defense counsel told the jury, quote, my client didn't even know the GUN was there. Counsel said Peterson's jumped in the seat after the girls are in the car. Counsel continued, they are trying to say my client knows the GUN was there and he touched the GUN and he put the GUN there. Why? Then counsel asked, was his DNA not found on the GUN? In short, the jurors were well aware that the prosecution had to prove Peterson knew the GUN was in the vehicle. Jurors are presumed to be intelligent and capable of understanding and applying the court's instructions. On the allegations that in committing the offenses in count 1 and 3, Peterson personally inflicted great bodily harm on Pete, the trial court instructed the jury with a CalCrim number 3160. The instructions state great bodily injury means significant or substantial physical injury. It is an injury that is greater than minor or moderate harm. Peterson cites a bench note following the instruction that cautions courts, quote, the sentence of the great bodily injury definition could result in error if the prosecution improperly argues great bodily injury may be shown by greater than minor injury alone. The note cites case law there. Any ambiguity in this definition is harmless in the case because substantial evidence established beyond a reasonable doubt that injuries Peterson inflicted on Pete were more than moderate harm. Indeed, they are more properly categorized as significant or substantial harm. Pete had surgery to remove bullet fragments in both feet. She had a lot of pain and couldn't walk for a while. Pete had physical therapy for a few months. The orthopedic surgeon who operated on Pete's feet testified at trial that the jury saw x-rays and a report of the operation. Surgeon told the jury Pete was placed under general anesthesia for the surgery. Surgeon described in detail the steps a team of 3 surgeons took to remove questionable tissue and the metal fragments, flush the areas, and close the wound with suturas. Pete was admitted to the hospital after the surgery. This testimony was more than sufficient to support the jury's finding that Peterson personally inflicted great bodily injury on Pete, such as in case law there. Peterson contends the prosecution engaged in prosecutorial misconduct in making improper comments during closing argument. According to Peterson, these improper comments consisted of improper appeals to emotion and sympathy for the victim, arguing facts not in evidence, and denigrating defense counsel. Peterson implicitly acknowledges trial counsel did not object to any of the statements in which Peterson now complains. The general rule is that a defendant may not complain on the appeal of prosecutorial misconduct unless in a timely fashion. And on the same ground, the defendant made an assignment of misconduct and requested that the jury be admonished to disregard the impropriety, such as in case law there. Oh, hold on, I'm fucked up. Where am I? Oh. Where are we? Peterson cites a case of the proposition that the forfeiture rule does not apply if an admonition would not have cured the harm, but he does not explain how admonitions here would not have cured any harm from the prosecutor's statements. In any event, Peterson claims of prosecutorial misconduct fail on the merits. A prosecutor's conduct violates the 14th Amendment to the federal Constitution when it infects the trial with such unfairness as to make the conviction a denial of due process. In any event, as noted, the court dismissed the great bodily injury enhancement at the time of sentencing. In other words, the misconduct or error must be of sufficient significance to result in the denial of the defendant's right to a fair trial. Even if the misconduct is not egregious as to render the trial fundamentally unfair, reversal is required if the prosecutor used deceptive or reprehensible methods to attempt to persuade either the court or the jury or the juries that are reasonably likely to have affected the outcome of the proceedings, such as in case law there. As we have explained, the prosecution's questioning of Pete about why she initially lied to medical personnel and police, the criticism directed at her after she accused Peterson and her attitude about the case and about testifying was not improper. Reference to the testimony and closing argument was not improper for the same reason. And for the prosecutor's reference in opening statement to what he expected Justin Edison to say if he testified, it is not uncommon for counsel on both sides to tell the jury that a particular witness will testify only to be unable ultimately to procure the witness's appearance. With respect to the prosecutor suggesting that Peterson tried to bribe Harris and his question, where's Justin, right? Pete testified, Peterson said, quote, don't tell on me and I'll give y'all $1 million if you don't tell on me immediately after the outing. Harris said the same thing in her September 2022 interview with prosecutors, though by that time of trial, 3 months later, she implicated about why Peterson offered her the money. Harris also told the prosecutor she met with Peterson outside of a hotel a day or two after the outing, and he asked her if she needed a job or if she wanted to work with him. He also mentioned investing into a business. Prosecutors may argue inferences from the evidence, such as in case laws there. When attacking the prosecutor's remarks to the jury, the defendant must show that in the context of the whole argument and the instructions, that there was a reasonable likelihood the jury understood or applied the complaint of comments in an improper or erroneous manner. Peterson has not made that showing here. Finally, regarding Peterson's assertion that prosecutors denigrated defense counsel repeatedly throughout closing arguments, this trial was vigorously litigated and hard fought. Both sides accused the other of misleading the jury. Defense counsel told the jury the prosecution case was full of holes and prosecutors had the audacity to ask the jurors to speculate. Counsel asked why the prosecution hadn't called Sean Kelly as a witness or the investigating officer, Detective Stogner. Counsel queried why the prosecutor had objected to Kelly's testimony. Quote, because they didn't want you to know the truth. Counsel asked, where is Jaquan Smith? Why didn't they call him? Quote, we had a lengthy discussion when I was informed of this over lunch with my client, my associate, and my investigator. We came to the conclusion that we're not going to call him because obviously his testimony is going to be putting the GUN in the hands of Kelsey. And that's what he told all of us when we just did an interview upstairs. At this point, my position was that the jury believes our theory. I think Sean Kelly already put the GUN in Kelsey's hand. And if they're going to believe that he took the GUN from him and you started to oot it yourself, to me, it's kind of absurd, kind of an absurd argument. Adding another person to say who has some connections to you as a security or friend isn't going to do anything. So we've decided we're not going to call him this morning. I told the prosecution we won't call him. I'll just move forward into argument. I'm ready. They're ready. Let's just argue and instruct and be done with this. Defense counsel explained further. And the reason for that, Your Honor, is obviously with the holidays coming, my fear is first, I'll lose this witness. This witness made it very clear he's not going to stay there. Secondly, and more importantly, I think we'll have a mistrial and we're going to lose jurors. The court asks, and you talk to your client, or do you need to speak further to him? Counsel replied, I've spoken to my client. If the trial continues another 7 days, we'll have a mistrial. My client definitely doesn't want that. My client wants closure on this. He has family flying back out to Canada, and he wants to finish this. To every evidence they've introduced, ladies and gentlemen, they've tried to mislead you, and none of the prosecutor's statements constituted deceptive or reprehensible methods. There were reasonable likely to have affected the outcome of the proceedings. The record does not support Peterson's contention that the prosecutorial misconduct inferred with its right to conflict-free counsel. Girl, I'm not reading the rest of all this, girl. My brain is like literally collapsing. Oh, we was already kind of at the end any motherfucking way. The conclusion is, girl, that no ineffective assistance of counsel or cumulative error, as we find no ineffective assistance of counsel or Prejudicial trial court error. We also find no cumulative error disposition. We affirm Daystar Peterson's conviction. And kaboom, bitch. She's serving 10 motherfucking years. Okay, miss me with the bullshit. My God, today. My God, today. So Daystar Peterson played into his own demise, girl. He was very aware of every freaking strategy and angle that his own legal team was going to take, girl. They had their own reasons for not putting their own witnesses on the damn stand, girl. And once again, just clogging up and holding up the court's damn time and attention. So the leprechaun will do his full 10 years. That's on period, girl. And Megan will continue, girl, to date and be in love and live her life, girl, and be an entrepreneur and make hip-hop great again by being the only hip-hop artist that's actually keeping hip-hop in the top damn 50 of the Hot Billboard 100, girl. Of course, it would take a woman to pioneer, right? Hey, Todd. Last minute, I said, yep, basically, there was no procedural law at all, girl. Tory Lanez is somewhere, girl, really like crying Megan Thee Stallion a river, girl. I mean, in the same week that your appeal gets overturned and concluded, you also have to still show up and participate in a deposition for her case against your paid surrogate. My God, today. And then his paid surrogate is also being sued by a whole nother party at the same time that she's having to fight it out with Megan Thee Stallion. My God, today. While Megan Thee Stallion is literally out here, girl, sitting on a biracial beard. I mean, you really can't make this shit up. It's almost like we're watching scripted television. Scripted television. This is crazy. I know he hot with no headline. It is a mess, y'all. This is a mess. And all under a retrograde, girl. A retrograde is the last astrological event that you want to have anything going on regarding contract communications, regarding jobs, regarding legal issues, girl, because you might go around and find out under a retrograde, girl. So this is a mess. Or if you've been, in your good energy, you may have the luxury of watching your enemies be done in, girl. And that's exactly what's happening to Milagro and what's happening to Tory Lanez. So Tory Lanez, girl, conviction, his appeal, girl, has been concluded. His ass will remain there for the next 10 years. He will be immediately deported to the Caucasus Mountains of Canada. And Megan will be seeing her cyberstalker harasser in court in just a few days, bitch, who is somewhere in the dark with double bags under her eyes and a plastic synthetic wig on her motherfucking head, talking about she don't know if she's going to make it, girl. It is literally a mess. So you guys thumbs up and you guys tell me. Oh, you meant with no hairline, my God, today. So you guys tell me what the hell you guys think in the comment section below about the shenanigans of it all, baby. Megan is the only one who got a smile on her face, girl, acting like she's not reigning in the goddamn apocalypse around here, girl. We're happy for her, girl. I love to see it. The consequences for Milagro are going to be extraordinary. She's already going into trial with sanctions. The judge also is going to allow Megan's counsel to prejudice the jury and let them know that Scams has deleted thousands of correspondences with Tory and Tory's father against the court's order. So literally, like, Megan is coming in with a win because the jury is allowing them to pretty much drag the shit out of Scams, girl, and let it be known that she been scamming her way through this thing, girl. That she been deleting evidence, girl. It's a mess. So she's coming in sanctioned. She's coming in prejudice with the jury. And imagine already owing somebody money, and then imagine the verdict being in favor of Meg. So then she's going to be responsible for the millions of dollars that Meg have spent on lawyers, legal fees, attorney fees. Meg has been in mental health recovery places. Girl, she's going to have to run Meg that punitive. She's going to have to run Meg that pain and suffering. Girl, it's going to be just as much of a debt as Trisha K. It may even be more, to be quite honest, girl, because I know that Meg done spent definitely millions of dollars on her attorneys. First and foremost, they have been working like a Hebrew slave since last year, girl. They've been filing away, girl. They've had to hire forensic investigators to jailbreak and clone Milagro's phones. They've had to find Zelle payments. They have spent lots of hours, day in and day out, scourging through all of Milagro's stuff. They've had to fly people in for depositions. I mean, all this shit costs. This shit is not free. Meg is paying for every single chapter and leg of her litigation against this fucking lady, including the cost of trial. And we obviously know that Megan is not suing Milagro for money. She know the bitch is broke. She know the bitch don't have no coin. That's not what she's going for. She is going for holding her accountable. She's going for introducing the same trauma into her that Milagro helped Tory Lanez to bring about to Meg's mental health. Meg is doing this on principle and for her personal vindication and self-pleasure. Watching her enemies suffer. And remember, this is a cyber stalking, cyber harassment, cyber crime case, which means that they're also more than likely going to attempt to strip Milagro of her online privileges as a result of finding her guilty of abusing her online privileges by way of spreading deep fake AI of a person, cyber stalking, cyber harassment, etc. Girl. So we literally could be witnessing the end of days for Milagro, girl. This could be the final chapter, girl. By next year, there may be no Milagro to stand, bitch, on social media. She may be effectively banned, and a judge does have the power to strip someone of their online privileges, either eternally or for years on end. And it has already happened on social media where people have lost their online privileges for a certain amount of time as a result of abusing and using their online privileges to incite particular violences and discomforts upon whomever the suspect is or whomever the victim is. So it's a mess. Both are coming for the content creators that are spreading lies. First, Brene. Who is Brene? Now, who is a Brene Airy? I don't know if you read it. I had to take a call. I read what, boo? We read probably about like 90% of the court's response to Tory's appeal. Yes. Yeah. Folks are not playing when it comes to being defamed by content creators. First, it was Brene. Okay. I still don't know who Brene is. But yes, there's been lots of defamation committed. That's why, girl, when you speak on anybody, whether it's a celebrity or it's another content creator, girl, you always talk from your personal experience. You speak from the factual place of allegedly, according to, and what you do know, you can emphatically cite. That's why I try my best to be very specific in my language as well, or according to, allegedly, or speaking from direct experience, and or I'm running the facts down on a bitch. I'm using their words. I'm using their interviews against them, girl. I'm just reciting, girl, what they've already laid out as the facts about themselves. But this is a mess. I'm surprised you don't know. No, I don't know. What I'm gonna have to look into the Brene situation that was national news. No, I'm gonna have to look into that. This is my first time hearing about the Brene situation. Andrew says the way Tory has literally contributed to half the world mentally abusing this woman should add more time to his sentence. I got a feeling that Tory can't help himself. I'm sure he's going to be doing things that are going to extend his prison sentence the way that P. Diddy ass is up in there. Getting his goddamn sentencing extended, girl. A mess. A whole mess. Some content creators don't have receipts. Then they're cruel too. Yeah, that's fact. They are. I can't drop the link, unfortunately, you guys. I have to get out of here. I have somewhere I gotta be. But I promise we'll come back tomorrow. We'll get into a conversation. I'll drop the link. You guys can come up here and pop the fuck off. We got to get into some other celebrity shit that's going on, girl. Miss Ray J done reverse Uno on the Kardashians. That's going to be fascinating, child. Oh, the age of Aquarius, girl. It got the closet wide open, baby. So if you ain't willfully coming out, bitch, you being forced out of that motherfucker, girl. The age of Aquarius is a hot motherfucking mess. But I got to go, you guys. I hope you guys have a wonderful night, child, and bless the motherfucking cane, bitch, because that reading, girl, is of another motherfucker. Is of another motherfucker, girl. Cash App, $, Consciouztv, and or PayPal.me/Consciouztv, spelled just how it is here on the channel. All social media handles are in the description box below. I love you guys a long time. Have a great Thursday. See you guys Friday. And I'll definitely see you guys on the 15th for my birthday. Love you guys. Bye.